Hi everyone, today we're going to talk about the national interest waiver. This is the EB2 category. Think of it like it's a mini EB1A case where you still can get a green card. So most people know if a company sponsors you, you can get a green card. You can go through the Labor Department process. You can prove to the world that the company tried to hire somebody but couldn't, and therefore they get a green card. So that's the normal green card process through a company. But if you can prove you are of national interest, you can get that requirement waived. You can self-petition. You can say to the government, you can say to the United States, hi, my name is, and I deserve a green card to come into the United States based on my resume, based on my ability. It's a little bit different than EB1A, the exceptional. You don't have to prove you are the best of the best in your field. You could just say, what I plan to do is so important that I deserve to cut in line and self-petition. Now, let me kind of read you some of the stats, okay? It's pretty alarming. In 2022 and before, generally speaking, 20,000 of these NIW applications are filed. In 2023, jumped to 40,000 pretty much. 2024 jumped to over 60,000, right? So it's over 190% increase than the baseline. The approval rate used to be 96%, then to 80%, then 40% or below. Okay, so that's 2024. And in 2025, I would not be surprised if that trend continues. There's a lot of reasons for this. If we're just talking about trends right now, right? In the first President Trump era from 2017 to 2020, it made it a little bit harder. But then in 2021 and 2022, President Joe Biden's policy on NIW specifically and USCIS guidelines actually made it significantly easier in the sense of clarifying some of the qualifications and opening it up to particular STEM majors. That's a huge one, saying because of the crazy shortage that we have in the United States on STEM majors and people who are in this field, that if you apply for NIW, generally we will give it to you, right? I mean, in so many words, when this was announced, we were physically at AILA, heard this news, we immediately made a broadcast on this issue, so many NIW cases. So if you look at it, 2022, that's why suddenly you see the numbers spike in 2023, 2024, right? This news was announced, policies went into effect, people prepared, people knew about it, filed, and suddenly, went from 20,000 doubling to 40,000 and then went to 60,000, you see? But in 2024 and 2025, things got a lot more stricter, frankly speaking. And naturally, because you just cannot approve so many things, so they had to make the requirements a lot more specific. Here's some like the big picture stuff, right? So, they made the first requirement for EB2 a little bit more difficult. You have to first meet the advanced degree and exceptional ability. How do you qualify that? They made it stricter. Then there was a higher scrutiny on the specific qualifications on what qualifies for the 5 years. And then just generic arguments about what you will be doing and how is it important to the United States, that also got a lot more specific as well, okay? So those are kind of the general ideas and policies. Let me see. Yep.
Got a question.
Cool.
Does national waiver can be on CSPA denied cases?
Wow, that's an interesting question. Okay, your question is, if your CSPA, which means Child Status Protection Act, if your case was denied, can you somehow argue national interest waiver and get a green card through employment? Right? So typically CSPA, you're under somebody else. You're under your family or you're under your parents' employment, right? Typically speaking. And then your case got denied because you aged out. You're over 21. That whole calculation didn't work out for you. Can you now apply for national interest waiver? The answer is yes. You can apply for any and all immigration categories. I think I did a video, there's like 43 ways to get a green card or something like that. You can apply for all 43. You can apply for EB1A, you can apply for EB2 NIW, you can apply for EB5 investment, you could apply for the golden visa if it comes out, you could apply for marriage, your parents, you could all the different ways. It's all available to you. Will it help? Tangentially, right? Sometimes we do applications where we have 3 or 4 applications at the same time. We kind of argue, hey, this person is extraordinary, and by the way, the spouse is a U.S. citizen. Oh, and by the way, they have a family petition, and in a few years they will get a green card. But if you approve this, they'll get it faster. So you're really just doing this kid a favor, right? So tangentially it can help, but it doesn't directly help the national interest waiver. Hopefully that helps you. Okay, so now back to the video on the policy part about NIW. So I want to talk about the trend, and I want to talk about specific case law and how to kind of overcome. What are some strategies that you might not otherwise know unless you practice this day in and day out, okay? I guess one of the first things I want to mention is that before you even apply for NIW, look into the Schedule A. What does that mean? Schedule A is essentially saying there's certain occupations and certain industries that we understand. You don't have to prove. You just submit your application, and it's almost, the NIW is almost already granted to you, right? You don't have to go through the labor of arguing. You're not competing in the workplace because we already know. So nurses, that's something that most people already know and understand under Schedule A, but physical therapists, what? That also qualifies. And let me read this specifically to you. There's also a group 2. It's the science or the arts. For purpose of this group, the term science or art means any field of knowledge and or skill with respect to which colleges and universities commonly offer specialized courses leading to a degree in the knowledge or skill. So, and also it says you don't have to have a college or university degree in order to qualify for this, right? So we've seen, let's say, some people who are artists. They make art, they don't necessarily study art, but they're just very talented. And then a college or university hires them to teach, and they have an O1 visa in the United States, or they have a J1 visa in the United States teaching, for example. Well, you could potentially argue the EB2 Schedule A Group 2 and say, I don't need to argue NIW because I fit in this category. I'm teaching for a university for a specialized course on a particular degree, and this is already approvable, right? So even before directly going into the NIW category, you could think about, okay, maybe this might fit. So again, a lot of people who qualify for O1 and J1s might qualify for this. So just kind of think outside the box. All right, so that's what I want to talk about for there. Now, let's really get into NIW. I see Catherine's face.
There's a question.
Okay, all right, I'll pause there. Go ahead.
Yeah, is there anything that I can do if I got deported from the U.S., but I was accepted for a SIG program?
Is there anything you can do if you already got deported? So, I'm sorry. Our firm doesn't really do that much with deportation or humanitarian cases in court.
SIG program? I don't know if that's
Oh, SIG program? Yeah, I don't know, right? So there are firms that really focus on deportation and humanitarian stuff. We primarily focus on family immigration and business immigration. But if I knew, I would totally answer, right? But thanks for asking. Really appreciate it. Now, we're going to talk about the actual NIW, National Interest Waiver. And this thing is constantly changing. And that's kind of the interesting thing about immigration law, where as each case law happens, and I'll tell you the stories about each one, you can see how, based on the policy, things are changing, right? So the first thing I want to kind of focus your attention on is it's a national interest waiver. It's waiving something, right? What is it waiving? It's waiving the labor certification. It is waiving an employer sponsoring you, right? Normally, you have to have an employer sponsor you. Normally, you have to go through the Department of Labor job test to see you are not competing in the U.S. workplace. A minimally qualified U.S. worker could probably do your job. National Interest Waiver is saying, no, I don't want to do all of that. I want to skip the line. I want to directly apply for a green card. This is something most people don't do. And I'm surprised. I mean, I see like 90% plus of NIW cases that other practitioners do. They don't do this, but I think it helps. Again, personal opinion here, but I do think it helps. Think about it. This is the national interest waiver. It's waiving that requirement. But what is to say you don't actually still find a sponsor who petitions you? Okay, now let me break that down a little bit. In a lot of NIW cases, you still want to prove what you're going to do, right? We're going to go in depth detail about talking about how to prove that. But in most cases, you're going to find somebody to help you to say you have a job or you're going to do something really important anyways. If you are able to convince them just to sign a form so that they are the petitioner, then you're waiving only half the requirement, thus significantly improving your chance of success. So again, I'm saying you're already doing the work. Just one additional conversation, have them sign the employment verification for you. So when you're filing for the national interest waiver, you are not doing a self-petition, you're doing an employer petition. I understand you might have a rebuttal right now saying, oh, but what if later on they're not willing to give me the job after I get my green card? Or what if at the green card interview, they're not willing to offer it? It's okay because it is NIW. As long as the work that you're doing, you're still gonna do. Even if you change the employer, it's still okay, right? There's case law precedent for that. So I'm just saying, because you're already finding different people that are hiring you to do a potential job, if they're willing to sign off on it, it significantly increases the chance of success, in my opinion. Okay, is there another question?
Yeah. I have DACA for 13 years. I did advance. I have a legal entry. How can I adjust my status to get a green card?
You have legal entry, you have DACA. So if you're able to marry a U.S. citizen, if you have another U.S. citizen, right, your parents that can sponsor you, then you can apply for a green card, right? But now, I just found out today, this morning, a lot of people who are going to these interviews, exact same situation, are getting detained. I'm finding out we already have a whole bunch of lawyers in the Santana office, in different offices across the country, and we're seeing this happen. I haven't made a video about it yet, but basically anybody who has had unlawful presence in the United States and you're going to an interview, even without criminal record, they're nabbing you. That is crazy, but we are seeing it happen. Is there a solution? My best recommendation right now is you lawyer up, in the sense of you prepare for a bond before you even go. The moment they nab you, you file it, and so you could try to get out within 20 days and prove to the immigration court that you're not a threat to society, and so you could get bailed out. If that sounds too crazy and too risky, I totally understand. I would advise not going to these interviews. In your case, you didn't even file the case yet, so, but I'm just saying, even if you file the case, that is something that we're seeing as of this morning. Crazy, I know. All right, going back to NIW. All right, so that's the first thing I kind of want to mention. It's a waiver of this labor certification employment process, but that doesn't mean you cannot actually have somebody sign off on it. Okay, so that's tip number one. Number two, and we're seeing this more and more these days, under the NIW requirement, right? If you're filing for EB2 and NIW, the first thing you have to prove is that you have an advanced degree, because EB3 unskilled professionals cannot apply for NIW. So if you're applying, you have to be an EB2 candidate. Now, to be an EB2 candidate, you need to show that you have an advanced degree. How do you prove that? The simple rule, everybody knows this, is you'd have a bachelor's degree plus 5 years experience, or you just directly have a master's degree. But now they're getting picky here, right? Because they're gonna say the 5-year experience, it has to be progressive. You can't just go from one retail job to another retail job, to all the exact same retail job. They'll consider that potentially 1 year and not 5 years. You want to kind of move up in the management chain. That's one requirement. And the second requirement is that the job experience, your degree, has to match what you're doing. That loosely makes sense. They weren't very, that was always the case. We've always made these arguments. We've rarely seen pushback, but now we're beginning to. So just be very mindful of that, right? Your work experience. And also, when you're submitting these applications, hopefully you're not showing your 20 years of work experience and just have the officer kind of pick through and decide which ones are relevant. You help the officer narrow it down. These were the time periods where I had that experience. So I prepared it. So now I qualify, right? So that's now before we're even getting into the nitty gritties of the NIW National Interest Waiver. This is a preliminary matter. And a question I get a lot is, can multiple degrees stack together to qualify advanced degree? The answer is yes, but you cannot stack multiple degrees together to meet the bachelor's degree, right? So you have to have the bachelor's degree, and then you can have work experience to make the advanced degree, or you can have multiple tangential degrees to make the master's degree.
We have a question.
Okay.
Expired green card 10 years.
Yes.
Also outside of the US. Apply for B1. It was granted. After watching your videos, I realized I technically am still a LPR. Can I enter US on B1 and renew green card?
That is the $1,000,000 question. So again, just letting everybody know the context here. You have left the country, your green card expired. In this case, you're saying it's 10 years. Some people it's 1 year, right? It doesn't matter. But the whole point is you were able to successfully get a tourist visa. And now your question is, can you enter as a tourist, renew the green card, and somehow get your green card back? So let me give you what is for sure, and then I'm going to tell you what the gray area is. What's for sure is you can only enter the country in one status, right? You can only activate one status. So you come in as a tourist, then you're a tourist, okay? Right now, this moment, if you come into the country as a tourist visa, you're a tourist, you're a non-immigrant, you're not a green card holder, you do not have the rights and privileges of a green card holder. And that is forever in your record. You leave the country, let's say you somehow get the green card, and you come back in, and you're coming in as a green card. Then the next time you come in, you're coming in as a green card holder. However, here's the gray area. Did you abandon your green card? The officer, CBP officer, at any time, that B1, B2, the new green card, or even 2 years later, after you continuously come in and out of the country, at any time, they can always check your record and say, it looks like for 10 years you weren't here, and you came in as a tourist. It seems like you kind of fell through the system and you've abandoned your green card. And so, I'm going to confiscate your green card and you have to explain it to a judge. So if you're looking for a definitive affirmative answer, as in, can I come in, get the green card, leave, come in, and then now I'm just forever a green card holder, I'm safe? The answer is maybe not. Have I seen people in the shadowy lands of immigration law do this? Yes. Is it legal? You're really on the edges here, and you're not safe. So, the best plan is to directly just enter the first time as a green card holder and not enter as a B1, B2, because that harms your chances in the future. But I totally understand the chance of coming in as a green card holder is extremely low given your circumstance because it expired, you've been out for so long. It's a very lawyer answer, I know, but at least I'm sharing all the things that I know, okay? Okay, now, back to the position. So here's now the second part of the first part of the EB2 and IW, right? So before we even get to the national interest waiver, right, you first have to meet one of two things. One, you have this advanced degree, and we already talked about how to prove it. Then the second part is you could prove you're exceptional. Now, if you're looking through the requirements, you see it online, you see, oh, it's 3 out of 6, and you're reading through the requirements like high salary membership. This sounds a lot like EB1A. And the answer is, yes, it is very much like an EB1A. It's rare that USCIS officers deny this at least in all the years that we practiced doing EB2 NIW cases, unless you do a really, really bad job, right? Maybe you just graduated a bachelor's degree, you have 1 year of experience, and you're trying to argue you're exceptional, and you don't have these, then yeah, it's a little bit harder. But typically, it is a mini EB1A. Think of it almost like it's an O1 level. It's not too hard to satisfy. You have good recommendation letters. You have a high salary in your field. You have some original contributions. Here's what they're looking for, right? Here's the parts that's different from EB1A, extraordinary green card. You have a degree relating to exceptional ability. Like, that's one of them. That's not an EB1A. You know, you can have 10 degrees and it still doesn't count. Here, you have a degree. Oh. Another one that they don't have, you have 10 years of experience. Oh, right? A lot of EB1A clients, they have like 30 years of experience and it still doesn't qualify for one prong. Here, a degree and 10 years of experience, boom, that's already 2. And then high salary, membership, or letters of rec, and bam, that's 3. So it's actually not too hard to qualify for this section of the EB2 NIW. So if you're looking at the requirements and you feel like, oh, that's so hard, and you're turned away by just the first part, don't be. The hard part is actually what I'm talking about now, right? So you still might be turned away, but the hard part is usually the second part. But it's also the fun part, okay? I'm gonna go through, even though we got a super nasty request for evidence later on, which we'll talk about, this is actually still the fun part, interesting thing. Okay. You always have to argue that whatever you're doing in the United States, there's a substantial prospective benefit to the United States, right? So I know we're going to talk about the national interest waiver, but you have to actually articulate it very specifically. What is the specific prospective benefit in coming here to do? You just spell it out, explain it in one paragraph. All right, so all of that is the preliminary argument. You should do it in 1 page, maximum 2, to talk about why you immediately qualify for EB2. And then we get to the national interest waiver. As you know, there are 3 prongs based on the latest case law. I have a strong feeling within the next year or 2 years, we'll probably get another case law that's probably not going to be as favorable as the one we have right now. That's just a pure speculation. Because prior to this case, the previous case, New York State Department of Transportation, that case was not favorable for national interest waiver. And then this new case, matter of Dhanasar, is favorable. Dhanasar, I'm sorry, I always say it wrong. I always say Dhanasar, right? Dhanasar. The new case law is beneficial. So, but seeing the trends, I have a strong feeling that they're going to rule it back a little bit. But we'll talk about that later in the future anyways. And you know what? The old law, the new law, this current law, and the future law, it's pretty much gonna be, it's similar. Okay, they're all gonna be similar. Just how you argue needs to be changed a little bit, and you'll see. Okay, I'm gonna go through it. Oh, sorry. Is there a question?
SIJ. Wait, let me see.
Yeah. Okay. While you look up the question, I'll take a drink.
I am SIJ can be approved. Can I travel to different states who have a lot of IC officers?
So the question is, am I safe to travel to a lot of places if there's a lot of ICE officers? Here's what the ICE officers have told me, okay? So you could directly reference what they're saying. They are after people who are undocumented and who have criminal records. And if you have a case that's filing and you have legal status here, you're not the top priority. So don't give them a hard time. They're not going to give you a hard time. With that being said, I don't know if that comforts you or not, right? That doesn't sound too comforting, right? It's like, it's like my kid runs downstairs and says, "Daddy, there's like a monster upstairs." And I tell him, "Don't worry. The monster only eats bad kids." Is it comforting to him? Probably not. This is a real joke that I actually did on him, by the way. So should you go to a place where there's a lot of ICE agents? Probably not, right? But just to let you know, if you have status here, bring with you so you can show, hey, I have status. Now, obviously you see on the news, and these are all real. People with F1 student status, people with green cards are still getting taken in because of political affiliation, because of what we see. That's frightening, you know. So, yeah, it's a scary time. Okay. All right.
It's crazy hearing these answers.
I know.
Like, it's just so
Yeah,
surreal.
it's surreal. You think it is just fear mongering online, but we are literally seeing this happen on a daily basis. So definitely prepare yourself. You know, will this end? Will it change? At least that's the current state of affairs. Yeah, it's bizarre. I get it. Okay. The national interest waiver, there are 3 prongs. We're going to go into the specific 3 prongs, but I first want to talk about what the original case law was that got destroyed by this new case law, and we can juxtapose it real quick, okay? So the previous one, in short, is the New York State Department of Transportation wanted to hire a civil engineer come in to do some really important work, and USCIS denied it, saying, no, sorry, he's not important enough, and here's the reasons why, right? And so in that case, they were judging the persons based on their substantial intrinsic merit, and it had to be national in scope, and the national interest would be adversely affected if this labor cert were required. So essentially, this new case law, the matter of Dhanasar, got rid of 3 words, okay? So, you know, all this talk about new law is favorable. It's just striking out a few words in the cases, okay? And a slight twist. So instead of substantial intrinsic merit, they took out the word intrinsic, so just substantial merit. And then instead of national in scope, it's national importance. Instead of the national interest would be adversely affected if this was to go forward, it became, would it be more favorable if this case would be approved, right? So instead of the negative argument, it's more of the positive argument, right? Optimist versus pessimist kind of a spin. So very, very similar, but it changed this entire world of national interest waivers, right? We're going to go into very specific details next to kind of break down what it means. So all I'm saying is that if there is a case law this year, next year, the year after, that comes in and revamps this place, national interest waiver argument, the law itself didn't change, just how do you interpret, what factors and what elements are you going to use? And again, it's always the same. Is it going to benefit the U.S.? That's you know, fundamentally the main argument, and just exactly how you argue it, okay? Okay, cool. Question.
Is the pressing concern of deportation very real?
Is the present concern for deportation real? If you are unlawfully present, if you have a criminal record here, that fear of deportation is definitely real, it should not be taken lightly, and to be prudent, you should have things in place. You should have powers of attorney in place in case you are taken away. Who's going to take care of your family? You should have guardianships in place. You should have, I don't know, finances in place to make sure everybody's okay. We should have a plan B. Does everybody else also want to leave? These are things not to be taken lightly. In a very real sense, we never know what's going to happen tomorrow. Car accident could happen and we could lose it all. So you should have all these things in place anyways. But if you are undocumented here, and if you are have any criminal records that are deportable, you should even more so be ready, because ICE is on the alert.
Oh, we have another question.
Okay.
Is speech language pathologist considered a good candidate for NIW?
That's a great question. A speech pathologist, is that a good requirement for NIW? Let's get to that, okay? So, we're going to talk about the Dhanasar requirements, okay? So there's 3. Let me think what is the best way for me to kind of go through it. I think the best way to go through it. You know, I think the best way to go through it is to yeah, well, yeah. My original plan, right? You go through it. Okay, so the first one. The first requirement, the first factor, substantial merit and national importance. Substantial merit and national importance. What the heck does that mean? What is substantial merit and what is national importance? I want you to think about it in terms of public interest and national scope. Okay, that's how I think it will be a good way to distinguish. What I mean by this, substantial merit. If you think about it, if you just think about it, everything can be argued to have substantial merit, has intrinsic value, has something that is beautiful and important in and of itself. Because, and I'm quoting USCIS, if it didn't, it wouldn't exist, right? Being a capitalistic society, if there's a job, if there's a service, if there's anything, it is important, or else it would be obliterated in this extremely capitalistic environment. So if people would spend time doing it, there's probably some merit and substantial merit. But what you want to prove that it's more than that. So in law school, we're taught to think public policy. When you're arguing before a judge, you want to argue public policy. Think of a lawyer who's arguing before the Supreme Court. And ultimately, that's how you should prepare all cases anyways, right? If USCIS just denies it, you bring it to a judge, federal judge. If the federal judge denies it, you bring it to the Supreme Court. And so you want to argue public policy. Is it in public policy's interest to approve this person's NIW case? Is there substantial merit? Is there public policy, right? So in your case, right, or in any case, let's take, for example, a speech pathologist. How important is that in the United States right here, right now, at this time for this case? Now, USCIS officer most likely have never spoken to a single speech pathologist ever in their life. Chances are, right? And anybody who's applying for these cases, again, these 20-year-olds, these 30-year-olds, who are working for USCIS, who are reviewing these cases, they don't have the expertise in every single field. So you have to educate them, right? So for example, prior EB-1A cases that we've done and EB-2 and IW cases that we've done, we have to lay out the framework. Why is this field in the national interest, right? The United States have the best doctors. Why should we let this doctor come in? Because the US has never dealt with a pandemic before. They know the solutions. That's a good argument. Bill Gates said it. The Bill Gates and Melinda Foundation have proven it. And this person worked on it. So they're coming here to help the US. You have to frame the picture. So if you can prove it's public policy that it's really good for the United States to advance this, then you can make a good argument for a national interest waiver. And that actually is a good distinguisher between EB-1A and EB-2 and IW. Because EB-1A, you just prove I'm the best in my field. You don't have to prove there's national interest in this field. You could be the best dumpling maker. You can make the best clay art dumpling dancer. That doesn't exist, but I'm just making it up. You see what I'm saying? Like, you show you're the best, and then you can potentially apply for EB-1A. EB-2 and IW, you need to show that there's this substantial merit. And then the second part of the first prong, it is national, what is it? Oh, okay. And then the second thing is there's national importance. Now, they were able to strike out the word scope in the first case law, but that's really what they're sort of thinking of. It's national importance, not necessarily in a geographic sense, because in the prior case, again, it was just New York. So they're saying, you're just helping New York, you're not helping the nation. But if you're doing something that's really important and your field of study is going to impact different industries all across the United States, then it's potentially helpful. For example, had that first civil engineer case for the New York case, had the matter of Dhanasar been the case law at that time, what they could have argued was that I'm a civil engineer, I'm coming to New York, I'm building out the metro, and yes, it directly helps the state of New York. However, the US metro sucks all across the country. New York is arguably already the best one, so my implementation of it would be the stepping stone for the rest of the United States. And the United States is really bad at subway stations and metros and public transportations, and so there's a national interest for me to do it. So had this case law been in effect, that's the argument you would have made, and that would have succeeded. And that's why it sort of, reversed it, because it was too narrow-minded, right? Somebody who's working for the New York State to build out this thing, and somehow it was too small in geography. So that's why they changed it to national importance. So now, as long as you can expand it, you can make the argument and you can win it. So that's the first prong, okay? The second thing is that the applicant is well positioned to advance this endeavor. I'll do that again. Okay. The second prong is that the applicant is well positioned to advance this endeavor. This wasn't part of the first case. This is definitely part of the second case. And now we are seeing that heavily focusing on adjudicating this. Do you have the right education? Do you have the right experience? Do you have the right projects? Do you have the right letter recommendation? What you do is important, granted, but can you do it? Now you make the link. And that is a difficult part, but it's also the part where you can just show all your supporting documents and evidence. Again, it's not EB1A. You don't have to prove you're the best of the best. You just have to prove that you can do it, that you've done it, that other people are not willing to do it, and that they have people vouching for you that you can do it, okay? And again, it doesn't mean you will do it, and it doesn't mean that you will succeed if you do it. It just means that you are capable of doing it. I always reference this movie. It is the movie Oppenheimer, okay? It took a lot of scientists to make this deadly bomb. There were a lot of things that they were trying. Most of them didn't work, but one did. Your goal in these NIW cases is to show you are just one of the scientists. There's a major problem, whatever problem in your public interest, whatever problem that you want to tackle, that you're capable of solving. There's many solutions. Your solution is just one of them, and you're capable of doing it. It doesn't have to be the best solution. It doesn't have to be proven that it's guaranteed to solve it. It might fail. That's not the point. The goal is you are well positioned to solve it, okay? This, I think, is the genius of these NIW cases. And I applaud the government for thinking of this, because it's very much research and development on a public policy, statewide immigration level, right? Think of a company that is trying to experiment with different things that can advance their company's interest. I don't know what is going to work, so let's let everybody try. And the one that does work, it pays for everything else. Think venture capital. So this is sort of the government's venture capital arm by giving green cards for all these people to come to the United States to implement their potential solutions to solve America's problems. It doesn't have to succeed. I'm not asking you to guarantee it, but just show me that you are at least well positioned to do it. You have the degree, the expertise, the job references to make it happen. So the fun part is the more bizarre your solution, the more beautiful it is. And I await a USCIS officer's denial saying that that solution is too far-fetched. Guess what? That's not your job to say it's far-fetched or not far-fetched. You're not the expert. The client is well positioned to solve that problem, right? You got a question?
Yeah.
Okay.
So, are there other options for an undocumented immigrant if they aren't eligible for NIW?
If you are undocumented, even if you are qualified as a national interest waiver, or you are the best in your field, EB1A, you still cannot adjust status in the United States. That is a hard truth that a lot of people have trouble swallowing. Let's say you win the lottery, you have more than $1 million that you can invest. Unfortunately, you still cannot get a green card because you've been undocumented and there's immigration law that bars it. Your record is already stained. So the family immigration law, there's only a few ways that you can still get a green card and adjust status if you're undocumented and if you're illegal and if you have certain crimes. No matter how good the business side is, it's only a supporting argument for your waiver, but it cannot directly get you the green card unless the law changes, which maybe it will, right? If President Trump is truly the deal maker that he is, thinking of capitalistic benefits, and this was brought to his attention that, hey, there are plenty of extremely capable, wealthy people that can invest in the United States, that can make the United States better and solve all these problems. What are you willing to give them instead? Potentially he will negotiate. And what he said about the $5 million investment in the Treasury to get a potential visa/parole, that might be his actual solution. Okay, so it's not a green card, but it potentially might allow you to work legally and travel freely. We'll wait and see.
Going to Japan, April
Okay.
30 to May 15, and got citizenship I-751 interview for May 8. Should I reschedule?
Based on those fact patterns, I don't think it's bad. You have a travel plan to Japan and you have a citizenship interview. Should you reschedule? Doesn't seem too bad. If you are going to a war-torn area that is an adversary of the United States, probably. But Japan, I think that's fine.
So can I board the flight as a B1 holder, but when I arrive at CBP request to enter as a LPR?
Oh, you will definitely have the potential to be dinged, right? Because you essentially lied to the airline, and then now you're entering with a different status. I've had lengthy conversations with CBP officers about this particular issue. Been both sides of this, okay? Both sides. The CBP officer seeking counsel on our end, saying this happened to somebody and they don't know what to do, and then we're letting them know what the law is. And then also clients trying to do it, and we're saying you have to really be careful. And this is the gray area, because are you lying to a immigration officer when you're presenting your information to the airline? Yes and no. You're talking to this person, but they are inputting the system into the airline, in which CBP checks on the back end. And so you are indirectly confusing them. So be very, very careful. And I've seen cases where like that happens, and now you have fraud on your record, and now now your B1, B2 gets denied, you have 5 years or 10 years cannot enter, and you also lose your green card, right? If you otherwise had an opportunity to get your green card back by just proving you did not abandon it, now you have a fraud on your record, so you can't even get it.
I am a pregnant resident. I got a class 1 misdemeanor. It's been dismissed. Can I travel out of country?
Here's something really most people don't know about under immigration law. It doesn't matter if the case was dismissed or not, right? And all the law shows and all the legal knowledge you think about is I'm innocent until proven guilty. Just because I've been arrested, just because I've been accused, just because the case was dismissed, I'm still super innocent. Not in immigration law. In a way, immigration law is even stricter than the military, in which even if the officer, CBP officer, consular officer suspects you have something wrong, they can detain you and they can inspect you, and then they could grill you, and then they could be judge, juror, prosecutor every single time. So just because your case was dismissed does not mean you're in the clear. Just because you were not convicted does not mean you're in the clear. Just because you succeeded once does not mean you will always succeed in the future. That is the reason why you need to become a citizen, because then that is a much stronger proof and shield.
Okay. I am undocumented with a deportation letter. I am currently at a university studying. Is it over?
Is it over? You're in a tough place. It is hard. Definitely be careful.
Oh,
Yeah.
okay.
Okay, cool. Now, continuing. So, that was the second prong. One of my favorite things, you just have to be well positioned to execute this dream and this plan that you have to solve the public interest, right? The third thing is that on balance, the waiver is beneficial to the United States. Here's something I want to actually read to you. The foreign national's unique knowledge or skills are not necessarily articulated in the labor condition, or it's a self-employed inventor may not to secure a job offer from an employer, or whether, even assuming a qualified U.S. worker, the country would still benefit from the foreign national's contribution, and whether urgency requires foregoing the labor certificate process. A showing of harm to the national interest is not required. So a lot of times I see NIW cases during the consultation and say, like, this is what we filed, this is a request for evidence, what happened. Most people just show, here's a problem I want to solve, I'm well equipped to do it, and there's a labor shortage. That is not a good argument, right? Because you're essentially cutting a line. And if you look at the stats, right, 60,000 people are cutting a line. If that many people are cutting a line, there is no line, right? The lines are just broken. So you want to show that we have lines. There should be lines. I'm not trying to cut the line, but I have such an urgent reason that I need to cut the line. And here's the reason why, because the line is messed up in my field, right? I'm an entrepreneur, I'm an inventor, I'm doing this thing. There is no, labor certificate code that really fits me nicely, or that there's just such a shortage of people. And what I'm doing is trying to advance the United States in such a way that is so crucial. Those are the reasons you want to argue. You don't want to argue just the bare minimum, right? You want to argue that the system that the United States set up is good, it's wise, it's smart, but I'm the exception. That is what you need to argue.
Just a heads
Yep.
up, it's 12:50.
It's 12:50?
Yeah. You have an appointment.
Yeah,
at 1.
at 1. Okay. Okay. Okay, let me see. I'm going to wrap up this overview. Okay. And that's it for the, okay, no, I'm doing it. And that's it for the overview of the national interest waiver. There's so many things I didn't get to talk about. The EB2 part, the EB3 part, how does it juxtapose to the EB1A, and so many other things. But just know that the United States immigration law is inflexible in so many ways, in the sense that you might qualify for EB1A, you might qualify for EB2, you might try the EB2 first and then halfway through convert it to a EB1A. You can go from EB2 to EB3. It's very flexible. And you can do all three at the same time if you really, really want to as well. I know plenty of people who have the EB2 already approved, but they want to change employers, so they do EB2 and IW. Some people have EB2 and IW approved, but they want to speed up the process, the priority date to get their adjustment status so their kids get green, so they upgrade it to EB1A. Again, you're just making the argument that you are important and you deserve a green card, and there's these different conditions and factors. It's a test of your writing skills and your research skills and how you position. It is super fascinating. It is one of the areas that almost all business immigration lawyers love. EB1, EB2, and IW. We definitely do a lot of it. If you have any questions, feel free to reach out. Thank you. Take care. Bye-bye.